Silence, court to rise. Appeal in Hallett and Derby Hospitals NHS Foundation Trust. Part heard.
Yes. I started yesterday by looking at the judge's findings as to the Trust's attitude to natural breaks and to the purpose of the monitoring exercise. What I propose turning to now are the contractual terms, that is grounds 1 to 4 of the appellant's appeal. And first to look at the F1 contract itself. As learned friend pointed out, it's recorded in paragraph 13 of the judgment that it was common ground that this contract was the principal document establishing the contractual terms and conditions of employment of Dr. Hallett with the Trust, and learned friend described it as the fountainhead. And the document, of course, is at tab 1 of the supplementary bundle. Clause 1, and I'll take this mindful that you've seen much of it before. Clause 1 is the offer of employment, which is to start on the 7th of August 2013 and to run for a year. Within that year, there are to be 3 rotations, and the one that's material to the present circumstances is the first rotation running from the 7th of August into December, so effectively a 4-month period. It was a full shift, and the banding had been assessed to be 1B, which gives a supplement of 40%. If the banding had been a 3, which is a non-compliant banding, it doesn't matter what the reason for the non-compliance is, but if it's non-compliant, then it would be a band 3, and the supplement in that instance would be 100%. So effectively, the doctors in training on the non-compliant Rotor get double the basic salary.
That's why you say it's a penalty.
Indeed, indeed.
There's nothing in between.
There are bands 1A and 1C. I'm not quite sure what the percentages are, but there's a significant leap up to band 3. So clause 2 states that the appointment is subject to the terms and conditions, which I will come to. 3A states that your hours and duties are as defined in your Rotor, and we've seen that that is the Rotor for breast surgery, full shift. And then at 3B, your working pattern is as outlined on page 1, with controls on hours as defined in the TCS paragraph 20. Then 3D is the payment of the supplement, which is to be payable in accordance.
Sorry, can you just pause a moment? I've been doing the clauses cited by the judge from her judgment, and I'm just comparing paragraph 15 of the judgment with what you've just read out.
So there's
she quotes 3A.
3A and 3E.
But then B, does that make it, does 3B change anything in 3A?
No, it's identifying that but it does identify that the control of hours are set out in the TCS, so it's a further reference to that paragraph 20 in the TCS. 3A is the working pattern, 3B control on hours. D is the supplement, I assume not quoted because there was no dispute about it. And 3E, which is quoted, the banding supplements may be altered in accordance with paragraphs 6E and 7C below in light of changes in working patterns in order to make post compliant with the New Deal. And it describes the mechanism for that.
Does this banding affect the entitlement to pension?
It's described, as I understand it, as a non-pensionable supplement in 3D.
Yes.
So that's my understanding.
That's the one, is it?
That's the one, yeah.
Okay.
3E cross-refers to 6E and 7C, just briefly to look at those on the next page. 6E requires the individual to work with her employer to identify appropriate working arrangements or other organisational changes in working practice which move non-compliant posts to compliant posts, and then to comply with reasonable changes. And then 7C, misnumbered, full details of the procedure for rebanding is in paragraph 22M of the TCS, which I don't think the judge set out in her judgment. If you would like a freestanding copy of the relevant parts of the TCS, then I have one, but I think the material parts are quoted in the judgment. Then, of course, one has 6A, which is the critical clause, that the trust is contractually obliged to monitor junior doctors' New Deal compliance and the application of the banding system through robust local monitoring arrangements supported by national guidance. And then the countervailing emphasis for the individual, you are contractually obliged to cooperate with those monitoring arrangements. Now, my learned friend yesterday said that if you were looking at the contract, you would naturally look to the national documents for the detail. In my submission, a natural reader of this clause would look to the local arrangements. That would be on a natural reading of this provision, where one would look to the source of the monitoring arrangements, the local documents. And the word that we see at the used twice in clause 6A, so you have local monitoring arrangements and then those monitoring arrangements, that word is picked up in 6B. These arrangements, so that is the local monitoring arrangements, will be subject to review by the Regional Improving Junior Doctors' Working Lives Action Team, or their regional equivalent, and for the Trust, the Performance Management Systems. And so, it is not expressed to be set at national level and subject only to national review or change. It is expressed to be subject to review, and it's a review at a regional level. And in my submission, this serves to emphasise the point that is at the heart of clause 6A, which is that the focus is on the local monitoring arrangements. They are key. 6C...
Now, just a minute. Before we leave 6A...
Yes.
There's 5 words on which we haven't focused so far. The Trust is contractually obliged to monitor junior doctors' New Deal compliance.
Yes.
Now, what does New Deal compliance mean?
New Deal compliance is compliance with the controls on hours.
Well, it's not a defined term, is it?
Not in the contract.
No. Right. So, the New Deal was a national collective agreement between the BMA and the Department of Health,
Yes.
Was it? Right. And where is it to be found?
The New Deal hours takes us, and I was going to come on to this, takes you into the terms and conditions of service, which are referred to in the contract, of course, at clause 3A. So those are your hours and duties as defined in your Rotor, which will not exceed the duty hours set out in paragraph 20 of the TCS. And the next, of course, refers to the control on hours in paragraph 20 of the TCS.
So, just a minute. So, what is the reader, the junior doctor on the Derby bus, as it were, reading clause 6A? what is meant by New Deal compliance?
That would have been understood generally as being compliance with the controls on hours. That is, the controls referred to in clause 3b as set out in TCS paragraph 20. And you'll see, if I may, that there's a reference to the New Deal in 3e as well.
Yes.
Banding supplements altered in light of changes to make posts compliant with the New Deal. And we will see this phrase emerge again in documents I will take you to shortly.
Yes. So you say that means, the New Deal means paragraph 20 of the Terms and Conditions of Service.
Yes.
Why not say so?
I don't know that. The New Deal is something which predated the agreement which led to this contract being formulated. And as you know, it's agreed that it's a contract which has its basis in a nationally agreed contract. But of course, this is the contract as implemented between the individual and the trust. But the New Deal predated that. And that is why, for example, you've seen reference to HSC 1998, which predates this set of materials.
The judge doesn't deal really with what the TCS is, and nor do we have it in the bundle. It's not difficult to see how it all fits together simply by reference to the judge's judgment.
As I say, I have here a copy of the TCS, if that would help. I've extracted from it.
Well,
But
whether it helps or not,
it's
we're unable to say if we don't see it.
It's what the judge had, and I think both parties are agreed that she's quoted the material parts. It's a very large document. It runs.
Oh, go on, Mr. Leeper. Let me have a look. Can I have a look at it just to see what it looks like?
As I say, I've only put in what I think are the relevant extracts. So you'll see on this, the judge has referred to version 10, and this is a copy of version 10, which is the one that was applicable at the time of Dr. Hallett's first rotation, and it was originally dated 2002, and the bit that I've extracted, which is, you'll see the first page is page 10 of 111, is the section that applies to practitioners in training grades. So it's a document which is intended to be comprehensive and relating to all NHS medical and dental staff. So those at every level of training and post-qualification, and it sets out terms in relation to those.
And it's a national document applicable to England.
This is a national document applicable to England.
And what is it as a matter of law? I ought to know this, but I don't. It's not a statutory instrument, but it's something published under statutory authority.
Yes, and it's been referred to as a collective agreement. You'll see that it's published by NHS employers, but it is something that was negotiated between the Department of Health and the BMA, essentially, and is a result of that collective agreement. My learned friend referred to some infelicities that result from that in the language that's used, because it's all part of a negotiation. But the core of it is to set out a system for, in relation to doctors in training, remuneration and relating to controls on hours. And what was nationally agreed, essentially, and the precise detail is what's an issue before you, what was agreed was that in relation to natural breaks, there would need to be 75% compliance with natural breaks. If there were, then it would be a compliance contract. If there were not, then it would go up to Band C. And the purpose of Band C is to incentivise employers to make sure that they get their working arrangements into a compliant realm.
Band 3.
And 3.
Sorry,
Yes.
perhaps, I'm so sorry, it's
Yes.
my fault. Band 3.
Yeah.
I hate to add confusion. Yes, Band 3.
So on any view, this document is incorporated into the contract, clause 2.
Yes, there was a reservation by the trust as to whether all aspects of it were, but certainly it's accepted that all material aspects were. Anything material to this case was incorporated into the contracts of the doctors in training and into, importantly, Dr. Hallett's F1 contract. So you'll see, for example, and some of this is quoted, you have definitions in clause 19. There are different types of rota. There are on-call rotas, so that is effectively those periods when you're out of normal hours, working out of normal working hours. There are partial shifts and full shifts and a hybrid. There are then controls on hours in 20. In relation to full shifts, one sees at C, the controls on hours are maximum average contracted at 56 hours per week, a period of continuous duty no more than 14 hours, and then 8 hours off duty between shifts, and so forth. So those were the controls on hours which were set by the New Deal, which predates this document. As I recall, slightly dimly, but there was a change in the level of, for example, maximum weekly working hours, because the aim was over a protracted period to bring it down from the level that junior doctors had been working to a more manageable level, ultimately one which would be compliant with the working time regs. But so that there was a shift. But as at this point, the maximum average contracted hours should be no more than 56 per week. Then clause 21, or term 21, deals with payment, and then you see references to New Deal compliant posts at the top of page 14. And at J, non-compliant posts, where a New Deal non-compliant post, pay band 3, becomes compliant then, and there are measures to affect the change to the banding levels in those circumstances. And the judge quotes from letter F on page 17, which is where Dr. Hallett's rota for rotation 1 was assessed to be, that is band 1B. And that meant that she worked within the controls on hours applicable to her working arrangement, so that was full time. And she worked on average 48 hours or less of actual work per week. So it would be New Deal compliant if she worked an average of 56 hours, but she's been assessed to be on band 1B, which is that she is working in the range of 48 to 40 hours on average per week. And that is another aspect of the monitoring process to ensure that the way that the rota works is that it, over the 4-month period, will meet that criterion, which is that the maximum working hours on average are between 40 and 48, so that it's properly assessed at being band 1B.
So then we go back to 22 for the supplements.
And in 22A, there is then reference to the HSCs 1998 and 2000.
That's right.
And specific reference at A5 and 6 to rest periods.
That's right. Now,
Well, it's 7, isn't it? Full-time shifts.
yes, so
Yeah.
7 is the natural breaks.
Yeah.
Yeah. Right.
Now, I think that's the part at which Learned Friend has said, if you applied this literally, that a doctor was not getting her natural break, then that would itself push up to band 3. But no one is operating on that basis. Everyone accepts that it is something that follows from a valid monitoring exercise. And if you look perhaps at 21P, which is on page 15, so this is under the heading payment. In the event of a rota without any change in working pattern being shown to belong in a higher pay band as a result of a valid monitoring round, pay at the higher level shall be backdated to the point, and so forth. So that identifies how the breach of any of the requirements for the controls on hours feeds into the banding. There needs to be a valid monitoring round, and if it determines that it should have been at a higher band because, for example, it is non-compliant as a result of that monitoring exercise, then band C flows from it.
why does a single missed rest break not trigger the pay increase for 3 months?
Because it has to follow within the language of 21p a valid monitoring round, second line. So if an individual were to say, I didn't get my natural break today, that means they haven't got their natural break, and they should have done. But that doesn't mean it triggers the pay hike, because what is looked at is the Rotor as a whole to see whether it is compliant or not compliant. And that, as the judge found, was the purpose of the monitoring exercise, and as was accepted by Dr. Hallett herself. And of course, if you look at the working time regulations for natural breaks, they give a right to a natural break, and the individual has a right to go to the tribunal and have a finding that there has been a breach of their right, a declaration that there's been a breach of their right to have a natural break. Then if there is a question of compensation, it's a matter of purely for the discretion of the tribunal, what it sees as just and equitable. And that may be nothing. And so what you have here is a mechanism which is seeking to achieve for these doctors, in the same way that they're not getting a capped 48-hour working week necessarily, but seeks to achieve that across the rota that they're going to be engaged in for 4 months, that it is established in such a way that there is compliance with natural breaks, but of course not full compliance. That isn't what is said.
You say of course, Mr. Leaper, but the contrast between 22A7 and which makes no mention of 75% or average or anything like that, with the rest of it, is very striking. 22A1 on average, 22A2 75%, 22A3 50%.
That of course is right, but there's no dispute between the parties that the applicable mechanism is the one which is set out at 21p, which is that your banding will increase if it's shown to be non-compliant as a result of a valid monitoring exercise. That there is no dispute between the parties that this is how the banding worked, and that is reflected in the F1 contract.
Right. And is valid monitoring defined in the in the T&CS?
No.
Well, I come back to the same question then. We're looking at rest breaks. What is compliance with the new deal? Why 75% as opposed to 99%, 50% or any other percent?
Well, in a sense, that's the issue between the parties. What is a valid monitoring round?
No, what is compliance with the new deal?
Yes.
What is it that you are monitoring in respect of rest breaks?
That there is a 75% compliance. And I'll try and show you where that comes from as we move through the documents. May I go back just to pick up a couple more clauses in the F1 contract, which is the fountainhead of these rights. So clause 6C on page 3 states that the trust must collect and analyse data sufficient to assess hours compliance, and the corresponding obligation on the doctor that when the trust reasonably requests you to do so, you must record data on hours worked and forward that data to the trust. And then again, at D, the trust is required to ensure that staff in all training grades comply with the control on hours of actual work and rest set out in 22A of the TCS, which is what we've just been looking at. Just lastly, you've seen on page 6 that there is a reference to copies of HSC 2031. That remains what I might call a floating reference. It's called Note 4, but no one has been able to identify what it is associated with. And there was no clarity offered on either side at trial in relation to that note. Now, we've just looked at the TCS. It is common ground and was before the court below, as one can see in paragraph 27 of the judgment, that neither the F1 contract nor the TCS in their terms spell out how monitoring should be conducted, what is a valid monitoring round, what criteria are to be met to establish non-compliance with controls on hours. So all of that is agreed. It isn't in the F1 contract. It is not in the TCS. And the judge recorded that at paragraph 27. There's just one point of clarification. In my learned friend's skeleton argument at paragraph 33, and there isn't a need to turn this up, they record this as being common ground, but add this, that the parties agreed that something had to be incorporated to fill that gap. But that, with respect, is not quite right. The trust doesn't say it's necessary for something to be incorporated. Its primary case is that the local documents were incorporated, but its alternative position was and remains that if they're not incorporated, they're an exercise of discretion conferred on trusts to make local arrangements. So our position is that it's not necessary that they be incorporated. They stand as an exercise of discretion in the alternative. But there is an express term which deals with monitoring, and that is clause 6A of the F1 contract. And it says that there is an obligation to monitor, and it must be done through robust local arrangements, and that these are supported by national guidelines. Dr. Hallett, as her colleagues were, are contractually obliged to cooperate with these monitoring arrangements, that's the local ones. And in my submission, the language there is inconsistent, wholly at odds indeed, with Dr. Hallett's approach, which is that there is a contractual obligation to monitor through the national guidelines. That approach ignores the express language of this contract, which is the fountainhead of her rights. You've heard the alternative.
You put emphasis on the word supported by.
Indeed. So the starting point is the robust local arrangements, and they are supported by national guidelines. This is language that, as we go through, as I'm about to do, the national documents themselves, is wholly supported by the national documents. They reiterate that this is to be done by local monitoring arrangements. That is language which one sees in the national documents again and again. And the spirit of those documents as well, as I'll show you.
The spirit also is that it would be consistent with national guidance.
Well, It says that it will be supported by.
Yes, I know it's saying it's supported by, but consistent would be implicit in that, would it not?
I see that, yes.
Yes.
Yeah. But then the question comes, if there is an inconsistency, if there were to be an inconsistency, what would be the remedy for that? And the answer in my submission to that question is that the overriding document for the purposes of the contract between Dr. Hallett and the Trust are the local arrangements. They're not effectively struck out by something that's in the national guidance. And if there is an inconsistency, then that is a matter to be taken up at trust level and with the Secretary of State to say these contracts do not properly implement the national guidance. But that isn't something which would confer a different contractual right on Dr. Hallett under this contract.
So you say that in case of any conflict between the local document and the national document, the local document prevails.
Yes, I do.
What's the sense of that in implementing a national policy?
Well, the sense in that is that, as we'll see when I get to the national documents, the emphasis is on the local trust to implement. It is part of the philosophy of devolution. And if the trusts do happen to get it wrong, then that is a matter to be taken up at the trust level and with the Secretary of State to say that this has not been properly implemented. It's not a matter which allows for construction of a clear statement in a local arrangement in a manner which departs from the language at the local level, wholly departs. I accept, of course, that if there were ambiguity, then it might be resolved by looking through the supporting national documents. That is, I see that as a legitimate way of contractual construction, but not one which allows a court or tribunal to disregard the express language of the local arrangements, because the national guidance is merely supportive of the local arrangements. It was so easy, as the judge herself found, it would have been so easy to say in this document, in clause 6A, a simple, straightforward matter, that the trust is obliged to monitor junior doctors' New Deal compliance by following the national guidance. It could just have said that. It could just have said, you must follow the national guidance. But it doesn't.
This is a standard contract, isn't it?
Yes, it is.
Presumably it's negotiated between the employer and the representative of the employee.
As I understand it, this is another document that was negotiated at national level. A template for it was negotiated at
But
national
you accept that TCS has inconsistencies which may have been satisfactory to both sides. Why shouldn't the same be said of this document? Both sides thought they were getting what they intended.
Well, the question for the court is what, of course, I say humbly, but the question for the court is to understand what the party's intention was, and that is set out here.
Objective.
Of course, objectively viewed. And objectively viewed, this contract says that the monitoring is to be done through local arrangements. It is to be supported by national guidance, but it is to be done through local arrangements, wholly consistently with the other national documents I'll come to in just one moment.
Come back to my first question. It's more monitoring of what?
And
Compliance with the New Deal. What does compliance with the New Deal mean? It can't mean something different in Derbyshire from what it means in Northumberland.
let me go then to the national documents, because what I say is that the express term in clause 6A and the fact that the monitoring exercise is to be found in local arrangements is entirely consistent with the national documents. So looking in the supplementary bundle, the first document, which is at tab 2 now, is HSC 98/240. Now this, self-evidently, is a document that dates from 1998, and as you've seen, the TCS themselves, I'm so sorry, my lord, it's tab 2.
Yes.
It predates the TCS, which you've seen were first introduced in 2002, and then go through a number of iterations. This document, as my learned friend accepted, is addressed to the trusts themselves. And at page 20, paragraph 1, it says its purpose is this: to provide guidelines for trusts and other signatories to the New Deal for junior doctors on the consistent interpretation of acceptable standards on juniors' working hours and living conditions. It sets out further points for trusts to action in making progress towards New Deal accreditation. And at 2, the New Deal hours controls are set out in Annex A. I'll come to those in just a moment. But there you have the New Deal hours controls. And this circular provides agreed national guidance in the following areas: rest requirements within New Deal working arrangements, which will be found at Annex B, and the rest aren't relevant. And then at paragraph 3, our aim is to encourage, that word, encourage a consistent approach across trusts and task forces, and to promote understanding where new guidance is being introduced. Then at paragraph 5, there is a ministerial commitment. At his speech to the BMA, the Minister for Health recognised that despite the hard work of NHS staff at all levels, there was still a hard core of problem posts. In asking trusts to review their local working arrangements, the Minister signalled that action on long hours will continue as a priority. And then the specific post is identified. So this records a ministerial commitment which asks trusts to review their local arrangements. And then at 9, trust responsibility. Responsibility for the successful implementation of the New Deal should rest with a named individual at trust board level. So responsibility for implementation is at a local level, at the specific individual at the trust board level. At paragraph 12, there's further reference to Annex B. The new guidelines in Annex B on rest periods may have an impact on some juniors' posts in trusts which have previously received full accreditation. To ensure consistency with the approach outlined in paragraph 11, that is the process leading to New Deal accreditation, task forces should work with already accredited trusts to check that in their ongoing monitoring they conform or are able to work towards these guidelines. Aspirational. And then at paragraph 13, the New Deal has long operated on the premise that local solutions to local problems are the best way to achieve sustainable improvements. This captures the philosophy of devolution to local level.
Does it? Or does it reflect the fact that there is national guidance identifying an approach which those at a local level are urged to implement consistent with the national guidance?
I don't disagree at all with respect. I don't disagree with that. But it is saying that the philosophy that's set out is that the actual implementation is a matter for local authorities to achieve. If I may, coupled with the context of paragraph 12, which is that task forces are seeking to check that there is monitoring either to conform or to seek to conform, to work towards. So this is not imposing an absolute it is saying that this is what we're aiming for, this is what trusts should be working towards. So that is definitely the aspiration. But it is also to be done at local level through, as it's put here, local solutions to local problems, and as it's put in Clause 6A, through the local monitoring arrangements. That is why I say that they are consistent with national documents. And there's a reference in the next circular as well, which replicates precisely the language of Clause 6A, the emphasis on the local monitoring arrangements. So that is why the trust's approach, and as the trial judge found, these are indeed guidelines, but they're ones which are to be implemented by local trusts through their own arrangements. This is the language of the clause, it is the language of this circular, it is the language of the next circular.
But speaking entirely for myself, what comes out of this document, amongst other things, is the word consistent. And it is consistent with national guidance.
It is seeking to ensure that there is consistency across trusts. That is absolutely right. That was the aspiration. It is seeking, as we see, and no doubt your ladyship has in mind, paragraph 1, a consistent interpretation. So it's providing guidelines on the consistent interpretation of acceptable standards. Progress towards New Deal accreditation.
Well, what I also have in mind, but I'm sure you're going to be coming to it, is page 47 and paragraph 26
I
of
certainly
the monitoring
will.
guidance.
Absolutely.
You'll
That
come
is,
to that in your
that
own
is at the
time.
heart of the dispute.
It is.
And my learned friend's submissions on it are, with respect, quite wrong.
Right. Well, you'll come to that.
And I
in
will
your own
come
time.
to that. It is at the heart of this dispute, I completely accept. If I may, though, there's a little bit of work to get there, at least in working through documents as at least chronologically.
Yes.
So Annex A to this circular, which you've seen is a document, is an annex, which sets out the New Deal hours control, paragraph 2. Annex A has a number of parts to it, and paragraph...
It says they don't apply, doesn't it?
yes, the following regulations, that's the following regulations do not apply. So,
This is to do with the working time.
yes, indeed.
Yeah. Annex B is the important one.
And exactly right.
Yeah.
And Annex B describes the Annex A is at page 24, is the bit that is the new controls on hours. So this is still part of Annex A at page 24.
Yes.
So the regulation doesn't apply, those parts of the regulation don't apply. This is what the New Deal says. And you have we're focusing for the purposes of this case on a full shift working pattern, minimum rest during duty periods, third column, says natural breaks. And it says note 3. So you see at the top of the column, in that first line across, it says brackets hours, but here there aren't specific hours, instead it says see note 3. And then note 3, information on how to calculate and monitor rest periods is contained at Annex B. Annex C deals with something different. And therefore we look to Annex B, which is at page 25. This has some key features, for example, that rest must be adequate to ensure safe working for the duration of the duty period. It then deals with a number of specific types of working, so which we've seen in the context of the TCS already, so the on-call rotors, the out-of-hours rotors, and that includes at paragraph 5 on page 26 a reasonable expectation. My learned friend took you to this, and my Lord Justice Bean pointed out it is specific to on-call rotors, but there is a reason for referring to it in a moment. As a guide, it should be possible for trusts to construct rotors in such a way that out-of-hours rest targets can be met during at least 3/4 of all rostered duty periods. This should be a minimum requirement, and if not met, the trust should urgently review the working patterns and so forth. So that's in the context of on-call rotors. The next relevant part is again the table that one sees at page 29, which is Appendix 1 to Annex B. And again, we have the various working patterns set out. We're dealing with full shift. Natural breaks has a tick. Minimum rest during the whole of each duty period at natural breaks. The minimum continuous rest guide, at least a 30-minute continuous break after approximately 4 hours continuous duty. And timing of continuous rest, and it uses the same language. So in relation to natural breaks, they should be given, and as a guide, they should be at least a 30-minute continuous break after around 4 hours of continuous duty. So that's the New Deal control on hours relating to natural breaks. And importantly, there is a footnote or a note at the bottom. And that is headed reasonable expectation of rest. In each of these working patterns, rest targets must be met during at least 3/4 of all rostered duty periods. Where the target is not met, urgent consideration will need to be given to changing the working pattern or reviewing working practices. Now that picks up on the language that we've just seen in paragraph 5 relating to on-call rotors. And the context of that paragraph is that it should be possible for trusts to construct rotors. So this is looking in the same way at the construction of the rotor, and the aim, the reasonable expectation, is that rest targets must be met during at least 3/4 of all rostered duty periods. So all of the duty periods that under a rota are put forward, those are rostered duty periods, and the target is 75% achievement in those rostered periods, the periods set out in the rota that's been constructed by the trust. That is what this note says about control on hours.
And this, on your case, is not a contractual document,
That's right.
but it's guidance which supplements the contractual document.
Yes, the language of the contract is that it supports, but it provides the context through which one can then look at the local arrangements, as of course we will in due course. But that is what this document is saying about natural breaks. It is 75% of the rostered duties should achieve natural breaks.
And is the interpretation of that footnote, is that a matter of law as to what it means, or does it mean whatever management say it means?
I say it's not a contractual document, and it is something which gives guidance to the trusts for setting their local monitoring arrangements. That's my primary case. I mean, even if the learned friend is right in that these are somehow incorporated, then it would become a question of construction. And in my submission, the only possible construction of this is that you're looking at the total number of periods which have been rostered into the rota by the trust at the beginning of the period. And you're looking at those duties, those periods that have been rostered.
Would it be open to a local arrangement to substitute a figure of 50%?
It would be open to it, but a matter which would certainly not politically open. Contractually
Well,
open.
I'm not talking about politics here. I'm talking about law.
Contractually open, I would say, of my primary case, yes, because it's a question of local arrangements. Of course, that's not what this trust did. I don't think it's said that any trust did that.
No, we're simply testing.
I understand and appreciate that. So my primary case is yes, it could be set at 50%, but this provides the national guidance.
So consistently with your argument, you say, well, if it was set at 50%, that is a matter which could be complained about.
Indeed, absolutely right, and would be vociferously and with real justification. But yes.
Why, if you're right, and it means what management say it means, subject to Dr. Hallett and others making individual complaints to tribunals, they've got no contractual rights at all.
Absolutely, that's absolutely right. But the grounds for complaint.
Why not 20%, 10%?
Because the grounds for complaint would be that there has been an entire process at a national level. Why is this trust deciding to depart from it so radically? And it would be something that I've no doubt that the Minister or Secretary of State would be concerned about.
But it's not a matter of concern. If it's set, my lord says, at 10%, the doctors are missing out.
Well, they would be.
They lose the contractual entitlement to
Yeah.
otherwise be entitled according to the guidance.
Indeed.
Well, it's a startling proposition from their point of view.
I've no doubt. I've no doubt. But I appreciate that one has to test a proposition. I completely accept that. But there's no suggestion that any trust did anything like that. People were, as this trust was found to be, seeking. I can only speak for this trust. This trust was found to be seeking to achieve compliance with natural breaks as set out here, and it did so through its local arrangements with an eye on the guidance that is set here. But even if this is incorporated, even if it were, what it is saying is there's 75% on the rostered duty periods. There's got to be compliance with those. And that is the language of this. It is nothing else. There is no other choice of language at this point. And this is the only source for the natural break compliance put forward by Dr. Hallett.
Well, she could have gone straight to Terms and Conditions of Service 22A7 and say that is agreed by all sides to be contractually binding. So the onus is on you to show that one missed break doesn't lead to the salary increase.
Well, theoretically, yes, but the answer to that is, well, there has to be a valid monitoring period, and then you have to look at, well, where do you find the source of the valid monitoring process? On the trust case, you look at the local arrangements, which say 75% compliance. On Dr. Hallett's case, you look at this document, and that says 75%. So there is not an issue between us. The question really is what is it 75% of? And I say that even looking at this document, it is clear beyond argument that this is referring to the rostered period set out in the Rotor that's been constructed by the trust. It is what the language says. It doesn't admit of other meanings.
The trouble with questions of interpretation, when one looks at the document, you say, it's obvious it means X. And Mr. Cameron says it's obvious it means Y.
Well, I'm not sure that he specifically addressed the language of rostering and what that means and how it fits in, and no doubt he will in due course, but how it fits into the fact that this is about a construction by a trust of a roster for a 4-month period, and then it is monitored. That whole rotor is monitored, and what this is saying is that the rostered periods, that is every period that is put into the rotor, 75% need to be compliant.
Okay, anything else from tab 2?
No, there isn't. May I then ask you to look at tab 3? Again, this is dated 2000, so it predates the TCS 2002. It is addressed to trusts, you'll notice its status, which is in the top band. I should avoid the word band perhaps, but in the top bracket, the status is described as information for information only. So that is the status of this document. And then at 39, page 39, there is a summary. It is addressed to...
Sorry, Mr. Lee, but
Yes.
before we lose that point, tab 2 said status action,
Yeah.
tab 3 says status information. Is there a difference from our point of view in the status of the two documents?
Really not, I have to say, because if you look at the next, if you look at what I was taking you to, which is summary, it sets out points for action for trusts, but that is how it is addressed. These are addressed to trusts for things that they should be implementing according to central government, essentially, with agreement for the NHS. This is what they should be doing. And the action points are set out in the bullet points that follow. Employers in NHS trusts need to make immediate arrangements to transfer existing junior doctors in post from their current controls to a new structure comprising basic salary plus banding supplements. So this is the action that needs to be taken to introduce what becomes the F1 contract. You need to get all of your staff onto something which will reflect the TCS, and rather than having the former pay structure, it will have the new pay structure, which is basic pay plus a supplement. And the supplement, obviously, is to reflect the control on hours and the compliancy. If there's non-compliant, then to band 3. So it's to fulfil that function of getting the junior doctors into the new pay system. And it's setting out what the employers should be doing. The purpose of the new contract, so this I don't think there's any dispute referring to the F1 contract, the purpose of the new contract at the bottom of 39, the new pay banding system is designed to support the modernisation of working practices in the NHS, provide a simpler, better targeted system for awarding juniors, offering the highest rewards to those in the highest intensity posts working the most unsocial hours, and then at the top of the next page, provide clear incentives to NHS employers to secure compliance with the new deal. Now that is obviously a reference to financial incentives, because if the working arrangements are not compliant, then they go on to band 3 and the 100% supplement applies. It is to balance between, you'll see in the bit after the bullet point, balance between the need for employers to provide a modern NHS service to patients and the requirement to adequately reward junior doctors for their service contribution. Then the monitoring arrangements heading, key principles and detailed arrangements for the transition period and for ongoing monitoring purposes after 1st of December 2000 are contained in what we can now describe as the monitoring guidance. But it continues. There will be a contractual obligation on employers to monitor hours compliance and the application of the banding system through robust local monitoring arrangements, and on individual junior doctors to cooperate with those arrangements. If either party is not fulfilling their obligations, this could affect the means of determining pay banding, and in some circumstances sanctions may apply. So this says, well, there's some guidance which we're about to turn to, and the way that this must be done is that there is a contractual obligation to monitor through robust monitoring arrangements.
And you say that's F1 6A?
Exactly right. It's exactly that. It is mirroring the language. But what this says is, well, there is some national guidance, but then when it refers to the contractual obligation on employers, which one finds in 6A, it is simply this: you must monitor in accordance with local arrangements.
it's not just some guidance. If you just look at that very first line under monitoring arrangements, key principles and detailed arrangements are set out in the monitoring guidance.
I didn't mean at all to be flippant by it.
I didn't think you were being flippant.
There is guidance provided.
Well, it goes
For
further
trusts.
than guidance. It's actually identifying detailed arrangements.
Yes, but it's calling that the monitoring guidance lowercase on the website. So the monitoring guidance, I don't disagree for a moment, the monitoring guidance includes a section called key principles and it contains detailed arrangements. But then it says, well, you as an employer, your contractual obligation to your staff is to monitor through robust local monitoring arrangements. That is the extent of that document. Now, then one turns, and your Ladyship will be happy to hear, to the monitoring guidance, or perhaps not. But that is at the next tab. Now, first of all, if I may, I invite you to look at paragraph 4 of this. This is headed Mutual Obligation to Monitor Hours, and it says, we've seen it before, from the 1st of December there will be a contractual obligation on employers. It's the language of 6A, it's the language of HSC 2031, and its emphasis is on the robust local monitoring arrangements. It gives context before that. The requirement for change, paragraph 2. There have been shortcomings in local monitoring arrangements, both in terms of coverage and accuracy. That's not sustainable. Why? There are 3 reasons. The key one, or the material one for present purposes, is the first. There's a new pay structure. Junior working hours will need to be monitored for duration and intensity, as that's key in determining individual pay bandings. Then at paragraph 7.
Well, you may want to 3 as well.
Yes, that's very fair. These developments broadly herald a move away from considerations of simple percentages in or out of New Deal targets, a more refined assessment of contractual working hours and work intensity. And the recognition in 6 that we've seen already in the HSC, in practice, if either the employer or the employee is not fulfilling their obligations, this could affect the means of determining pay band. Then at 7, and this is a point that your Ladyship will have identified, it again refers to seeking to, or to ensure consistency across the 8 English regions in implementing the new contract. The paragraphs below provide a national framework. They're an agreed set of key principles and standards and detailed operational guidance. The guidance outlines what should be monitored and when, so that information can be properly aggregated in trusts and regions and so forth. Then one has the key principles of Part B, and these are undoubtedly, they're high level, and at the top of page 44, one of the key principles is that properly resourced locally with the ultimate contractual responsibility for providing and overseeing monitoring processes resting with NHS trusts as the employers of junior doctors. So it is a key principle of this monitoring guidance that the ultimate contractual responsibility is on the trust, and that responsibility is in 2 parts. It is to provide the monitoring process and to oversee it. Again, an aspect in my submission of the philosophy of devolution. And then there is at Part C the operational guidance for introducing a national monitoring framework. There are various aspects to this which I don't think either of us say are particularly material. But if you look at page 45, paragraph 20 at the bottom, for ongoing monitoring, i.e. for both pay and new deal purposes, hours should normally be recorded and checked at a minimum of twice a year. Avoid non-typical periods where there's a change of house, where there are bank holidays, where there's examination periods. A monitoring period of 2 weeks is recommended.
How do you avoid a change of house?
So the change of house is talking about the shift in moving from Rotor period 1 to Rotor period 2. That's the house, the junior doctor's house, rather than whether Dr. Hallett was moving home.
House
House is
here equivalent to seat for trainees.
exactly right. Exactly right. And then we do get to paragraph 26 on page 47. And I hope not overly so, but I need to work through this in a little detail. Much of the data needed for assessing banding criteria or new deal compliance as listed above will already be available. And that includes contracts of employment, contracted duty periods, calculations for prospective cover within the team, the weekly shift rota timetables. So all of that material is available at the beginning of the house, at the beginning of the seat, because at that point the trust will have determined what the rota is going to be for that 4-month period, for the entirety of it. And all of this information is available to it without the need for specific information to come in from doctors on the ground. And it identifies that part of the data which is needed for this assessment includes what the contracted duty periods are. It also includes what the weekly shift and rota timetables are, i.e. what the rosters are over the relevant period, and it includes the calculations for prospective cover. So that is something which is specifically envisaged in the guidance as being a material aspect of the monitoring process. To that starting information, the information that you as a trust have at the beginning of the monitoring exercise, you are to supplement it, not supersede it. You are to supplement it with accurately recorded data. So, for example, data which relates to the actual length of the working week, if there are early starts or late finishes, the rest that's achieved during the day and overnight. Have you had a certain number of hours between your shifts? Whether you've got natural breaks, the actual working times as opposed to the roster duty periods. So we know what the roster should be. Is that being met? And the purpose of monitoring is because it may throw up situations where the working reality is very different from the expected working patterns, and it could indicate the likely source of non-compliance. So that is why I started by referring to the purpose of the monitoring exercise as found by the judge, as accepted by Dr. Hallett, which is to review the rota as a whole over the 4-month period. You start with the information which relates to that entire rota, and then you feed in, you supplement it with the data that comes in through the monitoring process. And that the supplementing data informs the starting data. And then you can assess whether overall the rota for the 4-month period is indeed compliant with the control on hours. That is how paragraph 26 in its terms operates. And my learned friend puts emphasis only on the second part. You've got to get accurate data about natural breaks. Of course you do. That is critical to the monitoring process. But it is part of it because it is fed into the information that the trust already has about how the rota will operate, and including the calculations that it has made in setting the rota for prospective cover. All of that is said in this document to be material information. it is an assessment, we see from that last sentence, of whether the expected working pattern is reflected or not in reality. And of course, the expected working pattern builds in prospective cover. In its terms of this paragraph, it does as well. And these are the rostered duties, those set out in the Rotor, that we have seen in Annex B, Appendix 1. And may I just, at this point, ask you just to look at the pleading on this. It is in the main bundle at tab 8, page 68. This is what the claimant said, that the effect of Annex B, Appendix 1, when read with paragraph 22 of TCS, is that a pay band at band 3 applies to a full shift working pattern where the rest target natural breaks comprising at least a 30-minute continuous break after approximately 4 hours continuous duty is not met during at least 75% of all rostered duty periods, and the claimant seeks a declaration to that effect. Espousing necessarily Appendix B, Annex B, Appendix 1. And so in my submission it is clear, both from Annex B, Appendix 1 and from paragraph 26 of the monitoring guidance, that all rostered duty periods are to be brought into account, and not the approach which Dr. Hallett is advancing to you and which she did to the trial judge unsuccessfully, which is that you need to discount some of the rostered duty periods for this purpose. I say the following by way of propositions that one can derive from the national documents, and I will give you references to back them up. The national documents are addressed to trusts. You see that at the very beginning of tabs 2 and tab 3 of the HSCs. It is a key principle, capital K, capital P, that ultimate contractual responsibility for providing monitoring processes, providing them, rests with the trusts, monitoring guidance, paragraph 9. This will be done through robust local arrangements, HSC 2000/31. This is because local solutions to local problems are the best way to achieve sustainable improvements. HSC 98/240, paragraph 13. Those robust local arrangements are supported by national guidance, monitoring guidance, paragraph 9. The national guidance contains operational guidance for introducing a national monitoring framework, monitoring guidance, paragraph 7. And those 6 propositions derived from the national documents support the obvious language of the F1 contract, which is that the details of monitoring are to be found in Derby's local arrangements. So that...
I've written down the 6, but I didn't get the cross-reference to where we find it in the national documents.
The sixth proposition.
Each one I failed to...
Is the easiest way of...
run through them.
Oh, right.
Yeah.
So the first, national documents addressed to trusts. That's the beginning of tabs 2 and 3, the HSCs. Key principle that ultimate contractual responsibility for providing monitoring processes rests with the trusts.
2.
That's the second, and that's paragraph 9 of the monitoring guidance. This will be done through robust local arrangements. That is set out in HSC 2000/31, under the heading, you'll recall on page 40 of monitoring arrangements. Fourthly, this is because local solutions to local problems are the best way to achieve sustainable improvements. HSC 98/240, para 13. Fifthly, those robust local arrangements are supported by the national guidance, monitoring guidance, paragraph 9. The national guidance, sixthly, contains operational guidance for introducing a national monitoring framework, monitoring guidance, paragraph 7. And the conclusion I draw from that is that this supports the obvious language of the F1 contract as set out by Darby to Dr. Hallett and agreed with her, which is that the details of monitoring are to be found in Darby's local arrangements.
You took us to monitoring guidance tab for paragraph 26.
Yes.
What do you say about paragraph 27?
Paragraph 27 is dealing with validity. So this is not about compliance. It's not about whether the 75% of natural breaks is achieved, and that is, as you've seen, 75% of the rostered periods, Annex B. But this is talking about the minimum return rates for monitoring data. So you have the 75% of all doctors in training in each rota or shift, and 75% of all duty periods worked over the monitoring period. Now I say, and I will take you to the local arrangement, which I say clarifies this. It is 75% where you've got the worked monitored periods of the total, that is, of the total rostered periods again. And that is what has been set out in the local arrangements.
Right, we'll come to that. But just
Yeah.
focusing on 27, you say this only deals with validity, not with compliance. But to be valid, there have to be 75% of all duty periods actually worked, not the deemed working.
Now I say that 75% of the returns must relate to worked periods of the total. So you're going to get returns which say I was on annual leave or non-returns. But 75 of them, to be valid, 75% must relate to worked periods. So when you submit, 75% of those returns must relate to a worked period.
Seems to me impossible, a matter of construction of the words in bold type.
That is the approach that the Trust adopted, and it's the approach that I say is the proper meaning of this.
Right, so you say that means, and this only goes to validity, you
Yeah.
say it's irrelevant to compliance, that 75% of all duty periods worked means 75% of that. It means 75% of all rostered periods,
Yes.
whether worked or not.
It means 75% must have been worked in the monitoring period.
Right.
Now, can I deal, please, with an argument which learned friend has put forward about the proper construction of Clause 6A. So they are saying this, that when it says robust local arrangements supported by monitoring guidance, the robust local arrangements have a very narrow meaning. And this is where we get to the man with the clipboard. So their submission is that when you look at Clause 6A, the robust local monitoring arrangements relate only to very specific details about how, in fact, you do it. Do you use a man with a clipboard going around counting whether someone's got natural brakes? Do you use a form of software in order to implement the checking process? So it is the real nuts and bolts, and it is confined to that. Now, I say that there are two reasons why that does not work. The first is that there's no reason to limit the meaning of local arrangements to merely administrative matters or to the designation of staff. And I hope you still have open paragraph 28 of the monitoring guidance. You may not. It's in the supplementary bundle, tab 4, page 47. So this, learned friends say, supports their construction of Clause 6A, because it says here that there should be clear local arrangements for the designation of staff to process, record and analyse data collected, together with robust performance manager structures at all levels in the NHS to perform that it's ensure that the guidance is observed in trusts. Now, learned friends say that is the delineation of the robust local monitoring arrangements in Clause 6A. That's how they are to be construed, as referring to those, the designation of staff who process, record and analyse data. Now, I say that is one aspect, of course, it says it is, but that's certainly not the limit of it. That is under the heading, how should the hours data be processed and analysed? Well, that's a matter for the local level. But remember that paragraph 4 of this same document, the monitoring guidance, is the one that sets out right at the start of this that there's a mutual obligation to monitor hours, one on the trust and one upon the doctor, and upon the trust it is one to use robust local monitoring arrangements. So that is the introduction to all that follows. Paragraph 28 is merely one aspect of what is to be done, and that is there's got to be robust arrangements for this identification of staff. But that isn't the limit of it. So just looking at the monitoring guidance, if it is a guide to the interpretation of Clause 6A, it doesn't work in that way. The second reason it doesn't work is that on Learned Friends' approach, the robust local monitoring arrangements are intended to deal with matters not dealt with in the national guidance. The nitty-gritty, which the national guidance doesn't condescend to deal with. His approach is, well, the national guidance doesn't need to specify whether it's a man with a clipboard or a bit of software. But that doesn't work with the language of robust local monitoring arrangements supported by national guidance, because this national guidance is not supporting those nitty-gritty points. His approach, or Dr. Hallett's approach, is to say that the local monitoring arrangements deal with stuff that isn't in the national guidance. But if that were right, then the national guidance couldn't support it, doesn't support it in any meaningful sense. And those two answers to the point were adopted by the judge below, paragraph 111 of her judgment, which is at page 158 of the core bundle, tab 11. My friend, I think, flagged this paragraph to you. Might I ask you to read it again to yourself in the context of what I've just said? So as I say, undoubtedly better put than I did, which is why I invite you to adopt that approach. So having looked at what the F1, the local contract says, what, in my submission, it means, the next question is Dr. Hallett right that the national documents are incorporated into the contract? And in my submission, they are not. Now, the starting point of principle I agree with, that there are two elements to be fulfilled in considering incorporation as set out in Alexander, paragraph 31. First, was it the contractual intention of the parties to incorporate those documents? Secondly, if so, are they apt for incorporation? As to the first, there is, in my submission, nothing to suggest that the parties intended to incorporate the national documents. Rather, the intention, as one sees in clause 6a, is to apply local arrangements. They're to be supported by national guidance, but they are at the heart to apply local arrangements. And if that's right, if that's what 6a says and does not reveal an intention to incorporate the national documents, there's no question about whether they're apt for incorporation. Dr. Hallett's approach is to say that there is a reference to the two HSCs in TCS paragraph 22, as Milady pointed out earlier. And there is indeed a reference to the two HSCs. It says, the controls on hours set out below refer HSC, and it gives the two numbers. What the TCS does at paragraph 22 is it sets out what the controls on hours are. And that is the cause for some of the difficulty in the approach, because it suggests that a mere breach is enough to push it into band C. But what 22 does is to identify what the controls on hours are. And it gives a cross-reference to say, well, yes, refer to the HSCs, they're there too, which they are. We've seen them in Annex A to the first HSC. So there, it is merely giving a cross-reference to another source for the same material. It does not refer in that context to monitoring. The alternative position adopted by Dr. Hallett is to say that there is incorporation by implication because something needs to be incorporated to set the criteria for validity and compliance. In my submission, there are two problems with this. The first is that was not Dr. Hallett's pleaded case. So again, could I ask you to look at the core bundle tab 8?
Are you taking a pleading point, or is this a jury point?
It is a pleading point. It may not be attractive, but it is. It's informative, at least, about the approach that was taken by Dr. Hallett below, which was unquestionably that this was an express incorporation, not that it was implied. So if one looks at tab 8 at page 68, paragraph 12, paragraph 22A of the TCS expressly incorporated the health circulars and therefore into the contracts of employment of the claimant and the represented class, and the claimant seeks a declaration to that effect. And then there's a description of what the HSCs say, and then at paragraph 17, the relevant provisions of the monitoring guidance as set out are expressly incorporated into the TCS, alternatively are the subject of a collective agreement and are apt for incorporation. So this is about express incorporation. The HSCs are expressly incorporated. But in any event, why Dr. Hallett says, and perhaps I should have done this the other way round, but the reason why what Dr. Hallett says is wrong is that she says, well, something needs to be incorporated. Something needs to fill this void. But that doesn't give you any steer as to why it needs to be the national documents or the local documents. It doesn't require, for any reason, that there be incorporation by whatever means of the national documents. Something does need to fill this void. Everyone agrees with that. It gives you no indication of what it is. What Clause 6A says is you start with the local agreement. Moreover, HSC 98, the first, does not deal with monitoring at all. And HSC 2000 refers to monitoring arrangements that explicitly says that this is to be done by employers through robust local arrangements, as we've seen. The only part of the 98 HSC which has a figure in is the one which refers to the rostering of 75% of, the compliance with 75% of all rostered breaks. It does not explain how that is to be monitored, the mechanism. The monitoring guidance is, in my submission, the national guidance which supports those local arrangements. So there's no reason and no intention revealed for these to be incorporated. The judge below went on in any event to consider whether the documents were apt for incorporation, and she determined that they were not. And this part of her judgment, which is, as you know, in tab 11 of the core bundle, is to be found starting at page 161. So paragraphs 121 to 125. I do not propose working through that reasoning, but I respectfully adopt it.
Understand paragraph 122. The contractual provisions are contained at paragraphs 20 and 22 of the TS, in particular 22A7. Right. They are agreed to be contractual. Annex B is merely guidance. What's the judge's finding as to what 22A7 of the TCS means?
As I understand it, it seeks to deal with the point that was troubling your lordship earlier about the potential for an easy breach, that there is a breach of the control of hours in an individual case, because it says if you breach it, then you're in breach and you can go to band C. And what her ladyship's recognising at this part is that it's implicit in the language of the TCS that you're dealing with the rotor as a whole. So a breach in an individual's not getting a natural break on a particular occasion, even though ostensibly it appears to be a breach of the particular paragraph. Everyone understands that this is operating in an examination of the Rotor as a whole, and that's made good by the provision that I've pointed to, which is that you're looking you only get to band C if there is a valid monitoring process. So looking at the Rotor as a whole. That's my understanding of that specific paragraph.
Right.
So, can I just deal with, there's one example given in my learned friend's skeleton argument about why the monitoring guidance is apt for incorporation, and that's by reference to paragraph 27 of the monitoring guidance, which is at the supplementary bundle at tab 4, page 47. What the language that the skeleton picks up on is this: a minimum return rate for monitoring data should be set at 75% of all duty periods worked under the monitoring period. And what this approach omits is, firstly, the language at the beginning, under this national framework. It uses the phrase that it should be set, and that begs the question, set by whom? It is to be set by a trust. So the trust has the ultimate responsibility. That's explicit in the terms of this guidance. It is to be set. And also, it has a proviso, which is omitted in the skeleton, provided that this is deemed to be a representative figure in both cases. So it doesn't have the crystal clear clarity that my learned friends advance. And it does emphasise that the exercise of setting is one to be done at the local level. Now, learned friends put this as his second main point, that if incorporated, paragraph 26 of the monitoring guidance makes clear that this is all about actual data. And I've addressed this already, I just touch on it in that context. And I say that paragraph 26 is clear that it is not only about actual data, it is about feeding actual data into the overall context of the constructed Rotor to provide the information. And I won't take you to it now, but for your notes, this is dealt with by Mrs. Justice, similar as she was at paragraphs 126 and 128 of her judgment, pages 162 and 163. So then, what are the local arrangements? The learned judge below accepted the trust's argument. These are set out in two documents, the Derby Monitoring Guide at S5 and the FAQs S6. And dealing with the other document, which is called the Policy on Monitoring, the trust never argued that contained the local arrangements. Dr. Hallett contends that this somehow acts against the trust because it's where you would expect to find the local arrangements. That I, with respect, don't understand. The document is expressed to be something at policy level. The two documents that the trust has relied upon and which the judge accepted to be the local arrangements are the ones which are addressed specifically to the doctors in training to inform them of their contractual obligations. And if one looks at the tab 5...
Does that mean that if a new FAQ is issued, that the contract is, in that respect, amended?
There would, well, it depends on not for a doctor who's already in place. So if as you see, the contracts operate on a yearly basis. So the contract is set forward in this context for the first year of the training. So in F1 it sets out and informs, and people are sent the local documents, or they're available to them, as the judge found. And so those set out the local arrangements. I don't suggest that at a whim the trust could send out local arrangements mid-contract without there being a formal variation in relation to them. And then, of course, at the year end, there'll be an F2 contract, and then one sees what the local arrangements are at that time. But the one that was the document that was material at the beginning of Dr. Hallett's first rotation is the document one sees at tab S5.
Just before we leave tab 7, you referred to this. This is a document which was before the judge but not mentioned in the judgment. What is its status?
It's the Medical Workforce Department's policy, an internal policy guide for the management of the trust.
Does it make any difference whether the workforce see it?
No.
It's just an internal document which can be totally ignored. So
Absolutely.
much waste paper.
Well, no, I shouldn't really say. I'm sure there's a lot of waste paper going around in policies and so forth, but that is what this document is. It's an internal policy for the Medical Workforce Department. The other documents are addressed to the junior doctors. They're made available to the junior doctors. And they were advanced at trial and accepted to be the local arrangements for the junior doctors, including Dr. Hallett under her F1 contract. And what one sees at tab 5 is a document at page 51 which is expressly stated to be, in fact it may be easier to look at it in the judgment, it's a matter for your lordship's ladyship. It's also quoted in paragraph 35 of the judgment at page 141 to 143, so extensively. And it sets out that the purpose of the guidance is to explain your contractual responsibilities and those of the trust as your employer for monitoring your hours of work to evidence compliance with the new deal and working time reg. So on its face, it is explaining the junior doctor's entitlements and the trust obligations and the junior doctor's own contractual responsibilities. It describes when monitoring happens, how it will be conducted through the software that was then called Circadian. It has the passage in the middle of page 142 as to when the monitoring period closes. So once the monitoring exercise has ended, you have 2 further days to log on and complete your working hours record. After this time, you'll be locked out of the system and the exercise will close. Then in the bullet points after that, the second bullet point, you must complete your duty periods as accurately as possible, including start and finish time, details of any breaks taken, any reasons for any additional hours worked. And then there is a number crunching and return rate section. A 75% doctor and duty return rate is required for a monitoring exercise to be valid. If it's not valid, there needs to be a repeat of the monitoring exercise. In some circumstances, a lower return rate may be considered valid. And then over the page in the judgment, page 143, paragraph 36, extracts from the frequently asked questions document. And the judge says that this provides insofar as relevant. Question 14, is a 100% return needed for each rota? And the answer from the trust, a 75% doctor return rate is required for each rota monitored to be deemed as a viable return, and a 75% duty return rate is also usually required, i.e. actual hours worked recorded, not annual leave, study leave, etc. So this is where I say it's clear that the meaning is it's 75% need to be actual hours worked recorded. and that is how it is described in question 14. And then question 20, what happens if there is a non-return? So it's a generally expressed question. And the answer is, for each exercise there are 2 return targets which are set at 75%. First is adopt a return rate, and an example is given. The second is the duty return rate. Any missing duties are taken from the planned rota, so that the monitored average hours are a true reflection of the planned rota. At least 75% of the duties taken into account in the monitoring analysis have to be monitored, which allows up to a maximum of 25% of substituted data for annual leave, study leave, or any shifts not recorded. And as the judge found, this is explicit as to the use of substituted data in this context. Now, it does, as Malone and friends say, refers specifically in this context to monitored average hours, but as the judge found, it is making clear to junior doctors that where there is a non-return, data will be substituted. And then, if I may, picking up in the judgment at paragraph 113, which is where the judge below dealt with this. It's page 159. So, firstly, paragraph 113. And this picks up on evidence that the judge below heard. The local arrangements are required to be supported by national guidance. In other words, consistently with what is contemplated by the relevant national guidance. It is unsurprising, therefore, that these documents do not state that they diverge from the national guidance. It's also unsurprising in these circumstances that Ms. Atkins, who was the witness on behalf of the Trust, supplied the auditor in the course of an audit with the HSCs and the monitoring guidance, and said that the national guidance in the HSCs have formed the basis of the Trust's Junior Doctors' Hours Monitoring Handbook and Monitoring Procedure. And unsurprising that she responded in cross-examination as follows. So far as you are aware, was there a positive decision by Derby to depart from the national guidance and to set up its own rules about monitoring? Answer, I think we follow the national guidance, but with local arrangements. That does not mean that the national guidance governed the individual employment contract, nor did Ms. Atkins acknowledge that the national guidance was part of the claimant's contract, as the claimant had suggested. And then she reaches her conclusions, and I know that you've seen this before in paragraph 114, as to what the meaning of the 2 local documents is. She found that it was in the language of conferring rights and obligations, that it set out targeted rules, and those are identified by her ladyship in the sub-paragraphs to 114. And again, I adopt those conclusions. And just to reiterate a point I made earlier on, as I have said, the Trust does not say that it's necessary for something to be incorporated. Our primary position is that these local documents were, but in any event, they were an exercise of discretion conferred on trusts to make local arrangements. And the judge accepted, as well as accepting the primary case, the judge accepted that alternative case, and that conclusion is in paragraph 118, which my learned friend read to you, or invited you to read yesterday, which begins, in the case of both points, if I'm wrong. In the light of the documents, all of the documents that I have reviewed this morning, I wish now to return to the monitoring system as a whole, just to perhaps develop what I started yesterday afternoon and I hope add a clarity to it. The judge found, and you'll see in her judgment, she records various points at which Dr. Hallett herself and her supporting witnesses agreed with some of these, or largely with these points, that the purpose of the exercise is to monitor the template rotor. That is what the doctors are contracted to, and it's the basis upon which their pay is determined, as we've seen by looking at the TCS. It is as a review of the rotor for the 4-month period and how it operates as a whole. The rotor is established in the first place. It is set up before the seat or the house begins. It is from that the initial banding is determined. It assumes within its construction by the trust that it is compliant with that banding. And that, as you've seen, involves a complicated assessment under TCS 22 to make sure that there are caps on average working weeks and the other controls on rest periods. Those are built into it. The further complication is that the rotor is produced and constructed on the basis of prospective cover. And so, rather than factoring in specific annual leave days that the trust is already aware of, because as you've seen, this is the very beginning of the contractual period, it won't be aware of any. Rather than hypothetically placing annual leave days on certain days and then requiring the doctors to take those, which obviously would not be an acceptable employment practice, the rota is calculated on the basis that allows for longer working hours so that there is adequate cover when an individual arranges to take annual leave. There is essentially slippage within the construction of the rota. In other words, people are deliberately working longer hours at times, but it is in the knowledge that this will be compensated for in due course when they're able to take their annual leave. This is determined by the application of a formula.
To write that down, it seems to me quite important. People are deliberately working longer.
Perhaps I should say deliberately rotated to work and therefore working longer hours at times. But it's in the knowledge that this will be compensated for in due course because they will take annual leave.
And how does that apply to natural breaks?
The way that the rota is constructed is that it assumes that natural breaks can be taken within the construction of the rota as it is. When there is annual leave taken, that is going to cause a pinch to those who are remaining because you've got an expected working period and others who are effectively covering for or working at the time when that expected rota period is not being covered. And that may create, in a particular circumstance, a pinch on the ability to take a natural break. And it is determined by the application of a formula and built into the system and built into what you've seen even in the national document is the concept that natural breaks are not uniformly going to be available, and that's why there is a 75% level set for achievement, not 100%.
I'm not sure I understand what you mean by compensating. It may be just the use of language.
Well, it is.
But so say that if people are made to work harder because they're eventually going to get a holiday, it doesn't seem to me in accordance with usual employment practice.
What I mean is that the way that the rota has been constructed is that it is accepted that people are going to work a certain number of hours a week when they're on a shift. And if one were doing it in an ideal world, where you knew when people were going to go on annual leave, you could arrange the shifts so that they would be slightly shorter, because you would know who was going to be on that day, which particular shifts were going to be covered, who was covering them, who wouldn't be. And so you could arrange it so that it was precisely right and gave people, in fact, more limited working hours during those times. But because it builds in the concept that people, at some point unpredictably, are going to be away, then the working times, and this is how it's nationally arranged to be, the working times are going to be slightly longer to allow for the annual leave cover to be taken in the course of the 4-month rotation, or indeed at any point in the course of the year. So it has to be constructed in that way to take into account what can't be predicted at the beginning of the rota period. And it's an...
This is the point you were making yesterday evening.
Indeed. Indeed.
The use of the word compensation.
Yes, I shouldn't perhaps have used that word. It recognises, there is a recognition that overall in the course of a rota things pan out, if I can put it that way. But in order for things to pan out, then there needs to be periods when it's that there is a higher expectation of the doctors in training. That is how the system works. It is the way that the rotas are constructed in the circumstances where you have a confined group of people. I'm not sure it's University 22, but we're working with 22. There are 22 people who are going to be covering have to be put in to cover the entirety of the periods of shift in that 4-month period. And that includes coverage of 24 hours, 7 days a week. And for some who are working in certain units, so if they're in intensive care, then there has to be a sort of, there will be a knowledge that there are going to be busier periods, say at night, so you're going to need more people at night, and you have to construct the rota in light of that. In others, and I suspect that surgery is one of those, there are more predictable times of working, but you still need out of hours cover, but you don't need so many people to be doing it. So it's an incredibly complicated process that works out for the different types of work in the different specialties within the hospital, what is anticipated as being needed, the number of doctors and the number of shifts that need to be taken. But you have to build into it that there are going to be times when people go on annual leave, whether it's for a more extended period or whether it's just because they want to take a day off to go to a wedding. And so that's the way it's constructed. It's determined by the application of a formula, as you can imagine. It's an inordinately complex exercise. And to that extent, the rota at the start is a theoretical construct, because it builds in something that one knows will happen, that people will go on annual leave, that people will be sick, but you don't know exactly when, as opposed to other working environments where there is a greater degree of predictability as to what people are going to be doing. And this was reflected by the judge in her finding at paragraph 70, which is at page 150. She said this in the first few lines: the rota therefore has a theoretical premise, as Mr. Wakeford, appearing for the BMA, also agreed that some of the shifts or duties rostered will in fact be taken as annual leave, but they're not identified, and nor is it possible to identify what type of shift the doctor will take annual leave from. And then moving up, please, if I may, to paragraph 67, and the last 5 lines of that. Although a 2-week period, so this turns to monitoring, although a 2-week period is actually monitored, the monitoring is directed at assessing the rota as a whole to see if it is fairly seen as compliant with its particular banding. Therefore, to produce an analysis, the software system refers back to the starting point for a doctor's working pattern, namely the contracted rota. So, if I'm may put forward a brief and I hope simple theoretical example. 3 people are scheduled to do a shift. If all 3 of those people are working, then there's every expectation that the hours will be compliant, that natural breaks will be compliant, and so forth. If only 2 are doing it on that particular day because the 3rd has taken annual leave, then this may cause pressure, may do, depending on how busy the particular shift happens to be, how many patients there are, what the particular circumstances are. It may cause pressure on the 2 who remain working, potentially causing an issue with natural breaks. The Rotor has been designed to anticipate those pressure points, and the 2 are under pressure, the 3rd is not. He or she is on annual leave. If the assessment were simply, as may seem intuitive, what happened to the staff who were working on that day, let's assume they didn't get their natural breaks because the 3rd was off, then it would show that 2 out of 2 on that shift did not achieve their natural breaks. But that is not the exercise. It is not the end of the exercise, because the assessment is not of that day's working. The assessment is of the Rotor as a whole, and whether the Rotor as a whole has been organised in a way which is compliant. As it's set up on that day in that example, the Rotor expected 3 shifts to be completed. Only 2 of them were done, and those 2 were not compliant. But you know the reason for this. It's because someone's on annual leave, and that's been anticipated within the Rotor template. If you recorded this as being 2 out of 2 not achieving natural breaks, that would be 100% not achieving, 100% non-compliant. The way the trust does it is to show effectively a 66% failure. So 2 out of 3 are non-compliant. It recognises that there is non-compliancy for those 2 who were working. That is the actual working of those 2 individuals, and that is reflected in the recorded hours that go into the monitoring process. But it assesses it within the context of the Rotor as a whole, which is that one of the people was off on annual leave, which has been fed into the Rotor as a whole. If that 3rd person had been working on that day, then it's highly likely that there would be 100% compliance, no percent non-compliance. So there has to be, to properly reflect how the Rotor is operating, you bring in the actual returns for the 2 people working, which shows that they were not compliant, but the Rotor has anticipated a 3rd shift, and that shows that that is said to be compliant to get a fair reflection of the Rotor. And the pressure on the ground on that day has been created by the 3rd person being on annual leave, but it is recognised in the data, but it's placed in the context of assessing the construction of the Rotor as a whole, because you're looking at a 2-week window and trying to extrapolate from that, which is what the national approach is, an extrapolation from the 2-week monitoring window to make sure that the Rotor as a whole is sufficiently, not wholly, sufficiently compliant. And as paragraph 26 of the monitoring guidance indicates, the construct of the Rotor provides information available to the trust, which is then supplemented by the actual data. So in line with paragraph 26, the information available to the trust at the start is how the Rotor will be expected to operate, and then you have fed in how it did operate, which is that 2 of the people within the 3 shifts couldn't take their natural breaks. But the 3rd shift, which is in the Rotor that day, is not non-compliant. You don't remove the shift from the expected shifts. And it's necessary in all of this to look at the purpose, which is why I started with it, of the monitoring exercise as a whole. Is the banding right for the rota that is being worked? That provides, I hope...
Well, can I apply this to a hypothetical situation? Suppose you have a rota of 21 people,
Yes.
of whom, because of understaffing or sickness or something, 7 are off sick for the whole 4-month period. You would say that, and the result is that nobody gets any natural breaks at all for the 4 months. What is the compliance figure? On your view, on your argument, all the people off sick or on holiday are deemed to have been present and taken their rest breaks. So the non-compliance is 2/3. It seems very odd. In truth, the non-compliance is 100%. Every doctor, every day, has taken no rest breaks.
But in that situation, you have got a position where this is not the fault of the rota as it has been constructed. And so the rota has been constructed in a way which anticipates that 22 people are going to be working, that they have annual leave, that there will be some periods of sickness. That's an extreme example which shows, firstly, that you couldn't really have a representative monitoring period because it would be unrepresentative of the rota as it should function.
Entirely in the situation I've outlined, which is admittedly an extreme one, it doesn't matter which fortnight you take in the 4 months, the result is the same.
Yes, but it is the way in which it's unrepresentative is that it is unrepresentative of the proper operation of the rota. This is not about securing on any particular occasion a particular individual's compliance with natural breaks, for example. It is about ensuring that the rota has been constructed in a manner which is designed to ensure compliance with that. Now, in that extreme circumstance, without question, the Trust would have severe human resources issues with crumbling individuals where they would need to find alternative measures to make sure that that part of the operation could be shored up, and would undoubtedly do it, however it was, bringing in locums at great expense to make sure that the patients could properly be looked after, as well as those who are working should not face intolerable circumstances. That is without question. That is not the exercise that is being addressed through this process. It is not seeking to determine that for those individuals working in that way, that they would be compensated by being elevated to Band C, because of course the way that the mechanism operates is that all of the junior doctors, including those off sick, would receive, and those on annual leave, all of their pay would be subject to the 100% supplement, because it operates across the group of people working the rota as a whole. So I completely accept that that would be an extraordinary situation. If it were to arise, it would be one that the Trust would be required to address, and address quickly, for everyone's health and safety. But that is not an example which triggers the operation of a banding increase, because it isn't about the construction of the rota. It is about an extreme circumstance which would have to be dealt with in and through other mechanisms, in accordance with the Trust's obligations to respect the health and safety both of its staff but also of its patients, because the patient's health would be at significant risk. It couldn't possibly have such a significantly under-prepared rota. It just couldn't operate in that.
Let me make the figure slightly less extreme. You have a rota of 22 people, and 4 are off sick for the entire period. The 18 who are left, let's assume, have no natural breaks at all. But you would say the box is ticked because they're no, sorry, I got the figures wrong. But you would have sufficient compliance for there to be the 75% box ticked, even though it was very common indeed to have no natural breaks.
I am sure that the Trust would not say that the box was ticked, because it would be facing a situation where it was not a representative period. You could not find a representative monitoring period, and so it would be unfit for monitoring. The answer to that scenario is not to increase the pay of the 22 doctors who are facing those extraordinary circumstances. It is to manage it, and to manage it effectively through alternative means. It is not this isn't, the corrective methodology for that is not to say, well, we need to find a way of making sure that the staff who are working get that higher level of pay, because that's not what, on any basis, this mechanism is about. The answer to that solution, which would be acute even in the scenario that your Lordship contemplates, the answer to that is through other and urgent mechanisms. The answer is not through anything to do with the assessment of the banding for that rota, because something else has gone seriously wrong and needs to be addressed.
Thank you.
Given what I've said, I'm going to deal with the question of rationality now, but I will be able to deal with it relatively briefly because of the context I hope I've given. Just one brief point of principle, which is, of course, that, as my Lord Justice Bean recognised yesterday, the IBM Dalgleish point about is it wrong is almost self-evident, and of course I accept that. What it doesn't do, that point, is highlight a point which I know will be in this court's mind, which is that the test for rationality is necessarily a high one. The court would need to be satisfied that the judge below was wrong because the Trust's approach was irrational. That is, one that no rational trust could have adopted. And what Her Ladyship below said at paragraph 137 was this: I consider that the only basis on which I could hold the defendant's approach to be unlawful is if its methodology is one that no rational NHS employer of junior doctors could have adopted. That's not challenged. The judge rejected the idea that this was a case in which specific criteria were to be applied to the exercise of discretion. That's paragraph 134, and again, that is not challenged. And so I say the question is this: was the judge wrong to conclude that the Trust's approach was not irrational? Because this court considers that its approach was irrational in the sense that no rational NHS employer of junior doctors could have adopted that approach. And in fact, Dr. Hallett's approach is that the Trust's mechanism is irrational because there is only one rational answer, and that is to adopt the methodology that she suggests. That is, in fact, the argument. There is a right answer to this, not a range of answers, and the Trust picked an irrational one. So, is there irrationality? The Trust contends that there is no basis for concluding that its approach was irrational. As the learned judge below concluded, the question is one of a choice of approach, each of which has its merits and its demerits. But the rationality question must be considered in my submission in light of three particular matters. First, and I reiterate but briefly, the purpose of the monitoring exercise. That is to look at the entire group of doctors on the particular rota and assessing pay for the entire group. And to do that, you capture an assessment of the whole rota rather than just the fortnight monitored. The claimant accepted that objective, judgment paragraph 69. Secondly, the judge below said this at paragraph 142, there is no perfect or objectively correct solution. The method that is advanced by Dr. Hallett itself involves the deployment of assumptions and extrapolation. And could I ask you to look, please, at paragraph 142 in the judgment, which is at page 166. Mrs. Justice Nicola said, although the claimant and the BMA criticised the use of assumptions by the defendant, their own proposed approach is also predicated on deploying assumptions and extrapolation. While their assumptions are more likely to favour the interests of junior doctors, that provides no proper basis for concluding that the defendant's approach is irrational. As Mr. Wakeford accepted, Mr. Wakeford for the BMA's preferred methodology, quote, involves an assumption in the way that any approach would do that lacks perfect data. He also accepted that any monitoring exercise involving duties for which returns are not submitted necessitates the use of assumptions of one sort or another. So in other words, you have 75% of returns and you have 25% of non-returns. Let's say for the ease of argument that those non-returns are simply because all of them were working, but they have not submitted returns. So it's simply a non-return situation. Dr. Hallett's approach is that you have 75% of returns. From those, you can work out the number of occasions on which there were not natural breaks. And then you extrapolate to the 100% from the ratio that you get from the 75%. So you extrapolate up, and for the non-returns, you are assuming on this approach that you've got the same ratio of compliant and non-compliant shifts on natural breaks. So no one knows what happened in those 25% of cases because they were non-returns. Dr. Hallett says the only rational approach is to assume the same ratio of non-compliancy for those 25%. The trust position is that it is equally, at least equally, but equally rational to assume that the non-returns were compliant. There's no reason not to assume that they were compliant. You don't have the returns. You have to do something with that data. It's missing. And so if you've got two alternative approaches, neither of which is irrational, then the trust has done nothing wrong by preferring a version which assumes that the non-returns are compliant. And that is in the context of my third point, which is, of course, that there is a contractual obligation on doctors in training to submit completed returns. Where a return is not submitted, there's no particular reason to favour the non-returning doctors or the doctors group as a whole. To put it another way, it's not irrational not to favour the doctors. As I said right at the start, the assertion that there's an equally probable answer for the non-returns, which is that people are too exhausted to make the returns, it is not actually what the judge found. There wasn't evidence advanced at trial that that was the reason why people weren't making returns. Dr. Potts sought to give some evidence along those lines, but that was rejected by the judge because she was able to complete them properly and diligently and gave great amounts of detail and put it forward. And there was no other evidence on which the judge could conclude, and she did not, that people were just too tired to make returns. So you have a situation of non-returns in breach of contract, and you have to do something with that data. And the trust assumes compliancy. And in my submission, there is nothing wrong with them. Once those 3 points are appreciated, that is the purpose of the monitoring system, that there is no objectively correct solution, and that there was a contractual obligation to submit returns, and those points are incontestable, there is simply no basis for contending that the trust's approach was irrational. And that reasoning, no doubt better expressed, is set out in paragraph 141 of the judgment at page 166. I see the time. I haven't much more to go, but obviously you'll want to do that after lunch. I would have thought, I've got just a couple of observations on that, and then I just need to deal with that single one-off ground 7, the MR2.
Thank you very much. Mr. Leeper, could I just give you a hypothetical for you and Mr. Kavanagh to think about, and you can give us your response at 2 o'clock, not now. 22 Dr. Rotor. During the critical fortnight, 3 are on annual leave, 2 are off sick, 9 complete forms saying that they got all their natural breaks, 7 complete forms saying that they missed at least some of their natural breaks, 1 was at work but didn't bother to return a form. Could I hit that adds up to 22, I think it does. I'd be grateful if you would tell me at 2 o'clock whether that passes the doctor
all of the tests,
all the tests, and whether they're compliant or not.
I'm very grateful to have the adjournment to think about it.
Yes, good. Right, 2 o'clock then. Thank you.
Bye.